Before we begin, a quick and important disclaimer. The information presented in this video is for educational and entertainment purposes only and does not constitute professional financial, legal, or tax advice. Divorce laws and retirement account regulations are complex and vary significantly by jurisdiction and individual circumstances. While we strive for accuracy based on historical trends and current statutes, the content provided here should not be used as a substitute for the counsel of a licensed attorney or a certified financial planner in your specific state. You are strongly encouraged to conduct your own due diligence and consult with qualified professionals before making any decisions regarding your marital assets or retirement accounts. In the vast, windswept landscapes of the U.S. Great Plains, stretching from the grain elevators of Kansas to the tech hubs of Omaha and the oil fields of North Dakota, a silent financial crisis is unfolding in the quiet corners of family courtrooms. Imagine spending 35 years building a life, braving the economic cycles of the American heartland, and meticulously contributing to a 401k with the dream of a peaceful retirement in the very communities you helped build. Now, imagine that entire lifetime of discipline being dismantled by a single 5-page legal document. In states like Nebraska, Kansas, and Oklahoma, the 401k is often the single largest marital asset, frequently surpassing the value of the family home or the farm equipment. Yet, it is also the most misunderstood. There is a shocking trend emerging across the Great Plains where individuals are losing 40, 50, or even 60% of their retirement's purchasing power not because of a market crash, but because of a failure to understand the intersection of federal law and state-specific equitable distribution. We are seeing cases where a simple oversight in a qualified domestic relations order, or QDRO, results in thousands of dollars in unnecessary taxes and penalties, or worse, the total forfeiture of survivorship benefits. This is the Great Plains Divide, a high-stakes legal reality where the rules of the game change the moment you step across a state line. If you think your retirement is safe just because your name is the only one on the account, you are standing on a fault line you didn't even know existed. Today, we are initiating a deep-dive masterclass designed specifically for the residents of the Great Plains who are facing the daunting prospect of a 401k split. The problem we are solving is the information gap, the dangerous space between what you think you own and what the law says your spouse is entitled to. By the end of this comprehensive guide, you will understand the precise mechanics of how retirement assets are valued in heartland courts, how to navigate the specific traps of equitable distribution states, and how to protect the tax-advantaged status of your funds during a transfer. We are moving beyond the surface-level advice found in generic pamphlets and diving into the historical trends of Midwestern case law. This is about securing your future in an era of uncertainty, ensuring that the harvest of your career remains in your hands, and navigating one of the most stressful periods of your life with the clarity of an expert. To understand the 401k divorce in the Great Plains, we must first look at the unique legal architecture of this region. Unlike the community property laws found in states like Texas or California, most of the Great Plains, including Kansas, Nebraska, North Dakota, and South Dakota, operate under the principle of equitable distribution. This is a critical distinction that many people miss. Equitable does not always mean equal, it means fair. In the eyes of a judge in Wichita or Lincoln, fair is a subjective term informed by the length of the marriage, the age of the parties, and the contributions each spouse made to the household. Historical trends in these states show that while a 50-50 split is a common starting point, the court has massive discretion to deviate based on the specific economic circumstances of the parties. Consider the 401k itself. Under the Employee Retirement Income Security Act of 1974, known as ERISA, your 401k is a federally regulated asset. This creates a complex layering effect. Federal law governs how the money can be moved, but state law determines who gets what. This is where many Great Plains residents hit their first major hurdle. In states like Nebraska, for example, the courts have historically looked at the marital portion of the 401k. If you started your 401k 10 years before you got married and then stayed married for 20 years, only the contributions and growth that occurred during those 20 years are typically considered marital property. However, proving what that premarital portion is worth today is not as simple as looking at an old statement. You have to account for the compounding interest and market growth of those specific initial dollars versus the marital dollars added later. In a deep dive into Kansas case law, we see that without meticulous record keeping, the court may default to assuming the entire account is marital property, effectively handing over a portion of your premarital hard work to your ex-spouse simply because of a lack of documentation. The tool used to bridge this gap between state divorce decrees and federal retirement law is the Qualified Domestic Relations Order, or QDRO. In the Great Plains, the QDRO is the paperwork executioner. Without a properly drafted QDRO, the plan administrator of your 401k, whether it is a major provider for a Topeka manufacturing plant or a small-town bank, cannot and will not move a single cent to your ex-spouse. We have seen case studies where a divorce was finalized in court, but because the QDRO was never filed or was drafted incorrectly, the retirement funds remained untouched for years. Then, when the account holder tried to retire or passed away, the legal nightmare began. In one notable historical trend within the North Dakota court system, a failure to specify gains and losses in the QDRO led to a situation where the alternate payee received only the flat dollar amount listed in the divorce decree from 3 years prior, missing out on a 20% market upswing that occurred during the lag in paperwork. Another layer of complexity unique to the Great Plains is the valuation date. In states like Oklahoma, the date used to value the 401k can be the date the divorce petition was filed, the date the couple separated, or the date of the final trial. In a volatile market, the difference between a valuation in May and a valuation in November can represent a swing of tens of thousands of dollars. Imagine a scenario in Sioux Falls where a couple separates during a market peak. If the court uses the separation date for valuation but the market drops by 15% by the time the funds are actually transferred, the person keeping the 401k might end up handing over a much larger, real percentage of their remaining assets to satisfy the fixed dollar amount determined by the earlier valuation. This is why understanding the specific timing rules of your state is not just a legal technicality. It is a vital component of your financial survival. Furthermore, we must address the tax trap that is particularly prevalent in the Great Plains, where many families rely on traditional 401k plans. When a 401k is split, the money is typically moved into an individual retirement account, or IRA, for the non-employee spouse. If this is done correctly via QDRO, there are no immediate tax consequences or early withdrawal penalties. However, historical trends show that many individuals, in an attempt to settle debts quickly or buy out a spouse's interest in the family home, will take a cash distribution from the 401k instead. In the Great Plains, where cost of living is lower but tax brackets still bite, taking a $100,000 cash out to pay off a mortgage in rural Nebraska could trigger a 30% combined federal and state tax hit, plus a 10% early withdrawal penalty if you are under age 59 and a half. Suddenly, that $100,000 is only $60,000. This is a potential outcome that ruins retirement plans before they even begin. As we move forward in this masterclass, we will examine the passive versus active growth debate that has dominated Great Plains appellate courts. We will look at how to handle outstanding 401k loans, a common issue for families in the Kansas City metro area who may have borrowed against their retirement to fund a home renovation or a child's education. We will also explore the often ignored survivor benefits, which can be lost forever if the QDRO does not specifically name the ex-spouse as a surviving spouse for the period they were married. This part of the journey is about more than just numbers. It is about understanding the legal geography of the heartland and ensuring that as your life changes, your financial security remains grounded on solid soil. We are looking at the long-term historical data to provide you with a roadmap that covers every bump and turn in the Great Plains legal landscape. To understand the first true obstacle in a Great Plains 401k split, we have to look at the concept of the wall of separation. In 2026, the legal landscape of states like Kansas, Nebraska, and Oklahoma has become increasingly sophisticated regarding what constitutes marital property versus separate property. Imagine John Miller, a senior project manager at an aerospace firm in Wichita, Kansas. John started his 401k in 2004, a full 8 years before he married his spouse Maria in 2012. By the time they reached the steps of the Sedgwick County Courthouse in early 2026, John's account had ballooned to $1.2 million. John assumes that because he was the one who spent years working overtime and maximizing his contributions, the bulk of that money is his. He believes the law will simply look at what was in the account on his wedding day and hand that back to him. However, historical trends in the Great Plains suggest a far more complex potential outcome. The first step in this deep dive is the identification of the separate property seed. In most Great Plains jurisdictions, the court views the 401k not as a single bucket of money, but as a growing organism. To protect his premarital assets, John must perform a forensic tracing. This is a step-by-step reconstruction of the account's history. It is not enough for John to show a statement from 2012. He has to prove that the specific dollars present in the account before the marriage remained there and grew independently of the marital contributions. This brings us to the first major technical hurdle, the commingling trap. Imagine if John, mid-marriage, decided to roll over an old 401k from a previous employer into his current 401k, or worse, into a joint IRA he shared with Maria. In the eyes of many Great Plains judges, this act of mixing separate funds with marital funds can lead to transmutation. Transmutation is the legal process where separate property loses its individual identity and becomes 100% marital property. By 2026, case studies show that even a single deposit of marital funds into a premarital account can, in some aggressive interpretations, poison the well, making it nearly impossible to untangle what belonged to John before the wedding. To avoid this, John's legal team would need to employ a forensic accountant to utilize a direct tracing method, identifying every dividend, every stock split, and every contribution from 2004 to 2026. This leads us to the heart of the math, the coverture fraction. This is the primary formula used across the U.S. Great Plains to determine the marital portion of a retirement plan. The fraction is relatively simple in theory but devastating in practice. The numerator is the total number of months the individual participated in the 401k plan while married. The denominator is the total number of months the individual has participated in the plan overall. Let's look at John's case again. John was in the plan for 264 months total. He was married for 168 of those months. His coverture fraction is 168 divided by 264, which is approximately 63.6%. Under this potential outcome, the court would take 63.6% of the current $1.2 million balance and declare it marital property, subject to a 50-50 split. However, we have to look at how different states in the Great Plains interpret this growth. In Nebraska, for instance, there is a historical trend toward distinguishing between active and passive appreciation. If John were in Omaha rather than Wichita, his attorney might argue that the growth on his premarital $120,000 was passive, meaning it grew simply because the market went up, not because of any effort or contribution made during the marriage. Nebraska courts have, in certain case studies, allowed the account holder to keep that passive growth as separate property. This is a massive distinction. If that $120,000 grew to $400,000 strictly through market forces, and the court accepts it as passive appreciation, John could potentially walk away with hundreds of thousands of dollars more than if he were subject to a standard coverture fraction split. Now, let's pivot to a different scenario in 2026 involving Sarah Thompson, a healthcare executive in Lincoln, Nebraska. Sarah is facing a divorce and has a significant 401k, but she also has an outstanding 401k loan. She borrowed $50,000 from her plan 2 years ago to help her sister with a business venture. This is a common situation in the Great Plains, where family ties and local businesses are often intertwined. The problem Sarah faces is that a 401k loan is not just a debt, it is an encumbrance on a marital asset. When the court goes to divide the account, they have to decide if that $50,000 debt belongs to the marriage or to Sarah alone. If the court determines the loan was used for a non-marital purpose, like Sarah's sister's business, they might credit that $50,000 against Sarah's share of the retirement. This means if the account was worth $500,000, the court treats it as if it were still $550,000. They give the spouse $275,000, leaving Sarah with only $225,000 and a $50,000 debt she still has to pay back to herself. This is the shadow math of divorce. It is not just about what is in the account today. It is about the historical trends of where the money went and why. Step by step, the discovery process in 2026 involves more than just tax returns. It requires a deep dive into the Summary Plan Description, or SPD. Every 401k has an SPD that outlines the specific rules for that plan, including how it handles qualified domestic relations orders. In the Great Plains, where many workers are employed by large agricultural cooperatives or regional utility companies, these plans often have very specific, non-standard rules. For example, some plans might not allow for a separate interest QDRO, meaning the ex-spouse cannot have their own account, but must wait until the employee retires to get their share. This creates a long-term legal entanglement that many people are desperate to avoid. Another layer of the 2026 Great Plains reality is the impact of the cost of living on these divisions. While a 401k split in New York or Los Angeles might be seen as just one part of a massive portfolio, in a place like South Dakota or Iowa, that 401k often represents the only liquidish wealth available to fund two separate households. We are seeing a trend where individuals are trading their 401k interest for the family home. This is known as an offset. If the house has $200,000 in equity and the marital portion of the 401k is $200,000, one spouse might keep the house while the other keeps the retirement. This seems fair on the surface, but it is a classic financial trap. The $200,000 in the house is post-tax equity. The $200,000 in the 401k is pre-tax money. If the person keeping the 401k eventually retires and withdraws that money, they will likely pay 20 to 30% in taxes. Their $200,000 is actually worth $140,000. The person with the house, meanwhile, has $200,000 of real, spendable value, without adjusting for the tax-deferred nature of the 401k, a process often called tax affecting. The person keeping the retirement account is effectively starting their new life with a 30% disadvantage. As we conclude this part of our masterclass, we have to look at the immediate risks of the 2026 market. In the Great Plains, where the economy is heavily influenced by commodities and energy, 401k balances can swing wildly in a single quarter. If you agree to a specific dollar amount in January, but the QDRO isn't processed until June, who bears the risk of a market downturn? If the market drops 15%, does your ex-spouse still get their flat dollar amount, leaving you with even less, or do they share in the loss? This leads us to the most dangerous phase of the entire process: the execution gap. You have the decree, you have the math, and you think you are safe. But between the courtroom and the final transfer of funds, there is a legal no man's land where a single mistake in a QDRO can cost you your entire survivorship benefit or trigger an immediate IRS audit. In the next part, we are going to look at the mechanics of the QDRO itself, the document that holds the power to bypass the IRS and move hundreds of thousands of dollars without a single penalty, but only if you know the secret language the plan administrators require. We will reveal why the default forms provided by your HR department are often a one-way ticket to a financial disaster, and how to ensure your 401k doesn't become a permanent link to your ex-spouse for the next 30 years. The complexity of the Qualified Domestic Relations Order, or QDRO, is often the point where the average divorce transition in the Great Plains turns from a civil disagreement into a multi-year financial quagmire. To understand why, we have to look at the legal architecture of 2026. While your divorce decree is a product of state law issued by a local judge in a place like Pierre, South Dakota, or Des Moines, Iowa, your 401k is a fortress protected by the Employee Retirement Income Security Act, a massive body of federal law known as ERISA. A state judge cannot simply tell a federal plan administrator what to do. The QDRO is the only legal key capable of unlocking that fortress without triggering the massive taxes and penalties usually associated with moving retirement funds. Imagine Mark, a technical lead for a major logistics firm in Omaha. Mark and his spouse decided to end their marriage in early 2026. During the mediation, they agreed to a simple 50-50 split of the marital portion of Mark's 401k, which was valued at approximately $800,000. Mark's HR department, wanting to be helpful, handed him a 3-page model QDRO form. This is the first major trap. Historical trends in Great Plains litigation show that these model forms are often designed to protect the employer and the plan administrator, not the individual participants. These forms are frequently shared interest models rather than separate interest models. In a separate interest QDRO, which is common in 2026 for defined contribution plans like a 401k, the account is literally sliced in two. Mark's ex-spouse would receive her $400,000 into her own brand new account, which she can then roll over into an IRA or her own employer's plan. She gains total control over the investments, the beneficiaries, and the timing of her future withdrawals. However, many HR-provided model forms default to a shared interest format. In this scenario, Mark's ex-spouse doesn't get her own account. She simply gets a right to a portion of Mark's future payments. This keeps the two of them legally and financially tethered for decades. If Mark decides to work until he is 75, his ex-spouse might not see a dime of her share until then. If Mark passes away before retiring and the model form didn't include specific survivor benefit language, his ex-spouse's share could vanish into the plan entirely, leaving her with nothing and Mark's estate in a legal battle with the plan administrator. The technicality of the language in a QDRO is so precise that a single missing word can alter the potential outcome by 6 figures. Consider the earnings and losses clause. This is a recurring case study in Great Plains family law. Imagine Sarah in Wichita, who was awarded $500,000 from her husband's 401k as part of a 2026 divorce settlement. The QDRO was drafted by an attorney who used a standard template, but forgot to include the phrase, plus investment earnings, and losses from the date of valuation until the date of distribution. Between the time the judge signed the decree in January and the time the plan administrator finally processed the transfer in August, the market saw a significant 12% upswing. Because those 4 words were missing, the plan administrator cut Sarah a check for exactly $500,000. The $60,000 in growth that her share generated during those 7 months stayed in her ex-husband's account. Conversely, if the market had crashed, Sarah would have still received the full $500,000, potentially leaving her ex-husband with almost nothing in his remaining share. In the Great Plains, where market volatility is a constant factor in 2026, failing to account for these fluctuations is a recipe for post-divorce litigation. Step 1 in a masterclass QDRO execution is the pre-approval phase. Never, under any circumstances, should you have a judge sign a QDRO before it has been vetted by the plan administrator. Most major employers in the Great Plains, from the energy companies in North Dakota to the manufacturing giants in Kansas, use third-party administrators like Fidelity, Vanguard, or Empower. These administrators have their own specific QDRO procedures documents. You must request this document immediately. It outlines the exact magic words that their legal department requires. If you submit a signed order that doesn't meet their internal criteria, they will reject it, and you will have to go back to court, pay your attorney for more hours, and potentially wait months for a new hearing date. By 2026, many administrators offer an online portal for pre-approval where you can upload a draft to ensure it meets their specific requirements before you ever step foot in a courtroom. Now let's look at the valuation date crisis, a specific hurdle for residents of states like Oklahoma and Nebraska. In your QDRO, you must define the exact moment the account is to be measured. Is it the date of separation, the date the petition was filed, or the date the divorce is finalized? In a fast-moving 2026 economy, this date is a moving target. Historical trends show that disputes over the valuation date are among the most common reasons for QDRO rejections. For example, if your 401k holds a significant amount of company stock, and that company announces a major merger 2 days after your date of final decree, the value could skyrocket. If your QDRO isn't specific about the effective date of the transfer, you are inviting a fight over who owns that sudden windfall. Another critical step often overlooked in the Great Plains is the treatment of plan loans. We touched on this previously, but the QDRO must explicitly state whether the alternate payee's share is calculated based on the balance excluding loans or the balance including loans. If James in Sioux Falls has a $401,000 but also has a $50,000 loan he took out to buy a new tractor, the total value for the purpose of the split is technically $450,000. If the QDRO says the ex-spouse gets 50% of the account balance, the administrator might only look at the $350,000 of liquid cash currently in the plan. This would result in the ex-spouse receiving $175,000, while James effectively keeps $275,000 in value, $175,000 in cash plus the $50,000 loan he already spent. In 2026, precision in loan accounting is a requirement for any equitable split. Finally, we have the administrative fee trap. Plan administrators do not work for free. They often charge a fee ranging from $500 to $3,000 to process a QDRO. The order must state who pays this fee. Does it come out of the participant's share, the alternate payee's share, or is it split 50-50? In many Great Plains case studies, this detail is forgotten, leading to a hold on the account while the two parties argue over a $1,500 fee, all while the market continues to fluctuate. You have secured the QDRO, you have the pre-approval, and the math is precise. You think the hard part is over. But there is a silent predator waiting in the 2026 tax code. Many people in the Great Plains think that once the money is in an IRA, they can use it to reset their lives, buy a new truck, pay for a move to a new city, or settle credit card debt. But there is a very specific one-time only Internal Revenue Code Section 72E(2)(c) exception that applies only to 401k transfers during a divorce. If you miss the window to use this rule, you could end up handing 40% of your hard-won settlement straight to the IRS. In the next part, we are going to dive into the divorce liquidity secret, How to access cash from a 401k split without the 10% penalty. A move that only works at the exact moment of the QDRO transfer and is lost forever once the money hits an IRA. We will reveal the step-by-step process for using this tax-efficient strategy to provide the liquidity you need to start your new life in the Great Plains without sabotaging your retirement. The heart of the divorce liquidity secret lies in a specific, often overlooked provision of the tax code, known as Internal Revenue Code Section 72(t)(2)(c). In the year 2026, as the economic landscape of the Great Plains continues to shift with the fluctuating prices of grain and the rising costs of suburban housing in metros like Des Moines or Wichita, this section of the code has become a vital survival tool for those navigating a 401k split. Typically, the IRS is a strict gatekeeper of retirement funds. If you attempt to withdraw money from a 401k before you reach the age of 59 and a half, you are met with a dual-pronged attack: ordinary income tax plus a 10% early withdrawal penalty. However, the QDRO creates a rare, one-time-only portal. When funds are distributed to an alternate payee, that is the spouse receiving the share, pursuant to a qualified domestic relations order, the 10% penalty is legally waived. This is not a guess. It is a historical trend in tax planning that remains one of the few silver linings in a divorce. Imagine Robert, a 45-year-old manager at a manufacturing plant in Cedar Rapids, Iowa. In 2026, Robert is finalizing his divorce. His ex-wife's 401k is being split, and Robert is set to receive $200,000 as his marital share. Robert is facing a common Great Plains dilemma. He needs $50,000 in immediate cash to secure a down payment on a new home, so his children can stay in the same school district, and he has roughly $15,000 in high-interest credit card debt accumulated during the separation. If Robert follows the standard advice of a well-meaning but uninformed friend, he might roll the entire $200,000 into a brand-new individual retirement account. The moment that money touches the IRA, the QDRO protection evaporates. If Robert then tries to take his $65,000 out of the IRA to buy his house and pay his debts, he will be hit with a $6,500 penalty on top of his taxes. By simply moving the money to an IRA first, Robert has effectively burned $6,500 of his future. The step-by-step strategy to execute this properly in 2026 requires precision in the drafting of the QDRO itself. You cannot wait until the money arrives to decide you want some cash. The instruction must be hard-coded into the document that the judge signs and the plan administrator receives. In Robert's case, the QDRO should explicitly state that the plan administrator is to distribute $65,000 directly to Robert as a cash payment and roll over the remaining $135,000 into his designated IRA. This direct distribution from the 401k plan to the alternate payee is what triggers the 72(t) exception. However, we must navigate the withholding wall. Federal law requires that for any direct cash distribution from a 401k, the plan administrator must mandatory withhold 20% for federal income taxes. This is a potential outcome that catches many Great Plains residents off guard. If Robert asks for $65,000, he will not receive a check for $65,000. The administrator will send $13,000 to the IRS and send Robert a check for $52,000. To get the $50,000 he needs for the house and the $15,000 for his debt, Robert must perform a gross-up calculation. To net $65,000 after a 20% federal withholding, Robert actually needs to request approximately $81,250 in the QDRO. We must also consider the state-level impact in the Great Plains. While the federal 10% penalty is waived, the money is still considered ordinary income. In a state like Nebraska, which has a progressive income tax system, adding $81,000 of income on top of a standard salary in 2026 could easily push an individual into a higher tax bracket. Historical trends in Great Plains family law show that failure to account for this tax spike can lead to a massive unexpected tax bill the following April. This is why we see case studies where savvy individuals coordinate with their tax professionals to split the distribution over 2 tax years, if the timing of the divorce allows, although the QDRO usually dictates a single event. Let's look at a different case study. Emily in Oklahoma City. Emily is 38 and receiving a $100,000 share of a 401k. She doesn't need the cash for a house, but she is worried about the 2026 inflation rates and wants to move the money into a more aggressive investment vehicle than her ex-husband's conservative employer plan allows. For Emily, the divorce liquidity secret is less about cash in hand and more about the strategic rollover. She needs to ensure that her IRA is established and the letter of acceptance is ready before the QDRO is finalized. In the Great Plains, where regional banks and credit unions are common, Emily must verify that her chosen institution can handle a QDRO rollover without labeling it as a standard contribution, which would be limited by the annual IRA contribution caps. The urgency of this one-time window cannot be overstated. Once the 401k funds have been moved into an IRA, you can never go back and claim the 72T divorce exception. It is a one-way street. If you are in Omaha, Fargo, or Topeka, and you find yourself needing liquidity 6 months after the divorce is final, and your money is already in an IRA, you are stuck until age 59 and a half, where you must face the penalty. This creates a massive psychological burden for many in the Great Plains who pride themselves on financial independence. They feel trapped by their own retirement savings. Furthermore, we have to look at the opportunity cost. While accessing cash penalty-free feels like a win, in the long-term historical trend of the U.S. stock market, every dollar taken out of the 401k at age 40 is a dollar that cannot compound over the next 25 years. In a deep dive into the math, if Robert takes that $65,000 out in 2026, and we assume a conservative 7% average annual return, he is potentially forfeiting nearly $350,000 of retirement wealth by the time he reaches age 65. This is the weight of the decision. Is the immediate need for a house in a stable Great Plains neighborhood worth the $350,000 hit to his future self? For many, the answer is yes, but it must be an informed decision, not an accidental one caused by poor paperwork. Step by step, the process for the 2026 Great Plains resident looks like this. First, identify the exact dollar amount of survival liquidity needed to reset your life post-divorce. Second, calculate the gross up to account for the 20% mandatory federal withholding and your specific state's income tax rate. Third, ensure the QDRO explicitly instructs the plan administrator to pay that specific grossed up amount directly to you while rolling the rest. Fourth, confirm with the plan administrator that they recognize the 72T2C exception so your 1099-R form is coded correctly at the end of the year. If the 1099-R is coded incorrectly, you will spend your first year of freedom fighting the IRS to prove you don't owe that 10% penalty. But what happens if the plan administrator drags their feet? In the Great Plains, where some of the largest employers are headquartered in smaller cities, the HR and benefits departments may only process QDROs once a month or even once a quarter. This leads us to the valuation gap. While you are waiting for your penalty-free check, the value of the 401k is moving. If the market takes a dive while your QDRO is sitting in an outbox in Wichita, the 50% you were promised might suddenly be 20% less than you calculated. In the next part, we are going to explore the high-stakes world of valuation protection. How to lock in your share so that a market crash during the administrative waiting period doesn't wipe out your liquidity and your future. We will reveal the specific language that forces the plan to protect your interests from the moment the judge signs the paper. The specific language that forces the plan to protect your interests from the moment the judge signs the paper is often the difference between a secure transition and a financial freefall. In the Great Plains legal landscape of 2026, where market volatility is frequently driven by rapid shifts in global grain markets and energy sector fluctuations, the time between a judge's signature and the actual movement of funds, a period known as the administrative waiting period, can be a dangerous no-man's land. Imagine David, an operations manager for a wind energy firm in Dodge City, Kansas. In early 2026, David and his spouse finalized their divorce, agreeing that his spouse would receive exactly $450,000 from his 401k, which was then valued at $900,000. Because they used a flat dollar amount in the decree without adding valuation protection language, David unknowingly assumed 100% of the market risk. While the QDRO was winding its way through the legal departments of a major national plan administrator, a sudden downturn in the renewable energy sector caused David's 401k, heavily invested in sector-specific funds, to drop by 15% in a single month. When the administrator finally processed the transfer, they took the $450,000 specified in the order and sent it to his ex-spouse. However, David's remaining balance wasn't $450,000 anymore. Due to the 15% market drop on the total $900,000 balance, the account had fallen to $765,000. After his ex-spouse's fixed share was removed, David was left with only $315,000. He lost $135,000 of his own retirement simply because he didn't account for the administrative lag. To prevent this potential outcome, the 2026 Masterclass approach requires the use of pro rata share language. Instead of a flat dollar amount, the QDRO should specify that the alternate payee is to receive a percentage of the account, for example 50% of the marital portion, as of a specific valuation date, plus or minus investment earnings and losses attributable to that share until the date of actual distribution. This ensures that both parties share the market risk and the market rewards during the waiting period. If David's QDRO had used this pro rata language, his ex-spouse would have received 50% of the reduced $765,000 balance, which is $382,500. David would have retained the other half. While both would have lost money due to the market downturn, David would not have been forced to bear the entire loss alone. Step by step, the first move in 2026 is to define the valuation date with surgical precision. In Great Plains jurisdictions like Lancaster County, Nebraska, or Oklahoma County, Oklahoma, the court may allow the parties to choose a date that makes the most sense for their situation. Common choices include the date of the divorce decree, the last day of the month preceding the filing, or a specific date agreed upon during mediation. Once this date is set, you must include a segregated account instruction in your QDRO draft. This instructs the plan administrator to move the alternate payee's share into a separate, non-fluctuating interest-bearing account, such as a money market fund, as soon as the QDRO is received for review. Historical trends in 2026 show that while not all plan administrators will honor a freeze request before final approval, many large-scale 401k providers for major Midwest employers have started offering this as a standard procedure to limit their own liability. Imagine if David had utilized a market-neutral transition. Upon filing the QDRO, his attorney could have requested that the administrator liquidate the portion of the 401k destined for his ex-spouse and hold it in cash equivalents. This would have effectively locked in the value at the time of the filing, regardless of what happened to the stock market over the next 60 days of administrative processing. For residents in the Great Plains who are receiving funds, this is the ultimate security blanket. It transforms a fluctuating asset into a stable one at the most vulnerable point in the process. However, there is a counter-strategy often used by high-net-worth individuals in places like Des Moines or Fargo known as the gains-only offset. In this scenario, the participant agrees to a flat dollar amount, but includes a clause that the amount will be increased by any market gains, but will not be decreased by any market losses. This is a highly negotiated point that usually requires a trade-off in other marital assets, such as giving up a larger portion of a brokerage account or a piece of real estate. While it sounds complex, in the 2026 economic environment, these asymmetric risk clauses are becoming more common as individuals seek to protect their liquidity for immediate post-divorce needs. We must also look at the dividend trap. In the Great Plains, many 401k plans for legacy companies or agricultural cooperatives pay significant quarterly dividends. If your QDRO states a valuation date of March 31st, but a major dividend is paid on April 15th while the QDRO is still being processed, who gets that money? Without specific language stating that all dividends and capital gains distributions shall be credited to the alternate payee's share in proportion to their interest, that money might default back to the participant. In a large account, these lost dividends can total thousands of dollars. Case studies from 2026 indicate that many self-represented litigants or those using generic online QDRO services lose out on this shadow growth, simply because they didn't know it existed. Another critical layer is the plan expense allocation. As we mentioned in previous parts, QDRO processing fees are standard. But in 2026, some plans have introduced account maintenance fees that are charged monthly. If the administrative period drags on for 6 months, who is paying those fees? Your QDRO should state that any administrative fees charged by the plan to process this order shall be shared equally by the parties, or shall be paid entirely from the participant's retained share. Precision here prevents a final check that is $500 short of what you expected, a discrepancy that can cause unnecessary friction and legal costs, just as you are trying to close the chapter on your marriage. Step by step, the 2026 Great Plains resident must, first, check the summary plan description for processing timelines. If the plan takes 90 days, you know you need robust valuation protection. Second, choose between pro rata percentage, sharing the risk, or fixed dollar with gains/losses, protecting a specific amount. Third, demand a liquidation to cash option if you are the one receiving the money, and the market looks unstable. Fourth, ensure all corporate actions, dividends, stock splits, or mergers, are addressed in the wording. But even with the most perfectly drafted valuation clause, there is a lurking variable that can upend everything in the Great Plains: the Social Security offset and the windfall elimination provision. For many public employees in states like Illinois or Missouri who may have worked across state lines in the Great Plains, their 401k or 403b might be their primary retirement because they don't qualify for full Social Security. In the next part, we are going to dive into the public sector trap: how to handle retirement splits when one spouse has a 401k and the other has a government pension. We will reveal why a 50-50 split of the 401k might actually be a 70-30 disaster once you factor in the Social Security equivalence math that Great Plains courts are using in 2026. This is the double-dipping controversy that is currently reshaping how teachers, police officers, and state employees approach divorce. The controversy of double-dipping in 2026 hinges on a fundamental misunderstanding of how retirement security is structured for public versus private sector workers in the heartland. To see this in action, we have to look at the case of Michael, a high school principal in Topeka, Kansas, and his spouse Linda, a senior analyst for a regional logistics firm. Michael has spent 28 years in the Kansas Public Employees Retirement System, or KERS. Linda has spent that same time building a 401k valued at $900,000. In a standard divorce scenario, the logic seems simple: split everything 50-50. Linda's attorney argues that Linda should get half of Michael's pension, and Michael should get half of Linda's 401k. On the surface, this is the definition of equitable. But in the Great Plains legal climate of 2026, this approach often leads to a massive structural imbalance because of two federal rules that most private sector employees have never heard of: the windfall elimination provision and the government pension offset. Imagine Michael's perspective. Because he is a public employee in a state where he does not pay into Social Security through his teaching job, he is not building the same federal safety net that Linda is. Linda's $900,000 401k is only part of her retirement. She also has a Social Security statement showing a projected monthly benefit of $3,000. Michael, however, has no Social Security from his primary career. If he worked a summer job at a hardware store and earned enough credits to qualify for a small Social Security check, the Windfall Elimination Provision, or WEP, will likely slash that benefit by up to 50% because he is also receiving a government pension. Furthermore, under the Government Pension Offset, or GPO, Michael is largely barred from collecting a spousal survivor benefit from Linda's Social Security if she were to pass away. In 2026, Great Plains courts are increasingly recognizing that Social Security itself has a present value, even though it cannot be legally divided by a state judge. Historical trends in Nebraska and Kansas show a shift toward the Social Security equivalence calculation. This is a sophisticated mathematical process where an actuary or a specialized financial analyst looks at Linda's projected Social Security benefits and determines what they would be worth if they were a private annuity. If Linda's Social Security has a present value of $600,000 and Michael's pension has a present value of $1.1 million, the court doesn't just look at the 401k in a vacuum. Instead of a simple 50-50 split of the $900,401,000, the court might look at the total retirement pot pension for 401k and the imputed value of Social Security. The potential outcome of this math can be shocking to the private sector spouse. In Michael and Linda's case study, if the court factors in the $600,000 value of Linda's Social Security, the total marital retirement pool is $2.6 million. If the court aims for a true equitable split, Linda might be allowed to keep her entire 401k and her entire Social Security, while Michael keeps his entire pension. To the uninformed observer, it looks like Michael kept his pension and Linda kept her 401k. But to the tax-aware legal strategist, this is the only way to prevent Linda from double-dipping, taking half of Michael's only retirement source while keeping her federal benefit that Michael is legally prevented from sharing. Step by step, the 2026 Masterclass approach for a public sector divorce requires a Social Security present value report. You cannot simply walk into a courtroom in Wichita or Lincoln and say Social Security is worth a lot of money. You must provide a report that accounts for the current year's life expectancy tables, the 2026 inflation adjustments, and a discount rate tied to the current yield of long-term Treasury bonds. This is where the depth of the deep dive matters. If interest rates are high in 2026, the present value of a future pension or Social Security check actually decreases. If interest rates are low, that value skyrockets. If your attorney isn't adjusting these numbers for the specific economic environment of the Great Plains today, you are essentially gambling with your lifestyle after 65. This leads us to the valuation of the pension itself, which is far more complex than checking a 401k balance on an app. For someone like a police officer in Omaha or a state worker in Pierre, South Dakota, the pension is a defined benefit plan. To divide it, you must first determine the marital portion using a time rule formula. But in 2026, we are seeing a rise in the use of the net present value method versus the deferred distribution method. In a deferred distribution, the ex-spouse simply waits until the worker retires to get a percentage of each check. This is risky because if the worker dies early, or the plan has weak survivor benefits, the ex-spouse could be left with nothing. In a net present value split, the parties calculate the total value of the pension today and use other assets, like the 401k, to buy out the interest. Consider the case of Sarah, a nurse in Fargo, North Dakota, who is married to a municipal worker with a significant pension. Sarah has a $401,000. The actuary determines that the marital portion of her husband's pension is worth $500,000 today. Instead of filing a complex QDRO for the pension and another for the 401k, Sarah might agree to waive her right to the pension if she can keep her entire 401k and receive an additional $50,000 from her husband's share of their home equity. This is a clean break. It avoids the administrative fees, the long-term legal entanglement, and the risk that the pension plan's rules change 10 years down the road. However, the trap for public employees in the Great Plains is the tier system. Many states like Oklahoma or Kansas have modified their pension plans over the last 2 decades, creating Tier 1, Tier 2, and Tier 3 benefits. If you started working in 2005, you might be under a far more generous tier than someone who started in 2018. Historical trends show that attorneys often fail to distinguish between these tiers when calculating the marital share. If a 401k is being used to offset a Tier 1 pension, but the math was done using Tier 3 projections, the participant is effectively overpaying for their own retirement. In 2026, the specificity of the tier is as important as the dollar amount in the account. Furthermore, we must address the Qualified Illinois Domestic Relations Order, or similar state-specific equivalents for Great Plains residents who may have crossed state lines for work. Each state in the region has its own specific form and its own specific interest rate that they use to calculate buyouts. If you are using a national actuary who doesn't understand the specific statutory interest rates of Nebraska, your pension valuation could be off by 20%. This is why a local deep dive is the only way to ensure the 401k split is truly fair. The 401k is often the equalizer in these public-private splits. It is the liquid currency of the divorce. While you cannot trade Social Security and you cannot easily liquidate a pension, the 401k can be moved, rolled over, or cashed out. But as we move into the final stages of the masterclass, there is an even more pressing threat. Even if you get the Social Security offset right, even if you value the pension correctly, and even if the 401k split is perfectly executed, there is a ghost in the machine: the beneficiary designation. Historical trends show that more retirement assets are lost to forgotten beneficiaries than to bad market cycles. In the next part, we are going to explore the lethal beneficiary loophole, why a judge's signature in 2026 might not be enough to stop your 401k from going to your ex-spouse's new partner 10 years from now. We will reveal the step-by-step process for overriding federal preemption and ensuring that your 401k actually reaches the people you love. The lethal beneficiary loophole is a legal collision between state-level domestic relations law and federal retirement statutes that catches thousands of Great Plains families off guard every year. To understand the gravity of this situation in 2026, you must recognize that your divorce decree, signed by a judge in a local courthouse in places like Salina, Kansas, or Grand Island, Nebraska, is essentially a piece of paper that federal 401k plan administrators are often legally required to ignore when it comes to who inherits your money. This is the concept of ERISA preemption. Under the Employee Retirement Income Security Act, federal law trumps state law. If your state has a statute that says divorce automatically revokes a beneficiary designation to an ex-spouse, which many Great Plains states do, that state law is generally preempted by ERISA for 401k plans. This means the plan administrator is legally bound to follow the plan document rule, which states they must pay the person named on the official beneficiary form in their files, regardless of what your divorce decree says. Imagine the case of Marcus, a heavy equipment operator in Sioux Falls, South Dakota, who finalized his divorce in early 2026. Marcus and his ex-wife, Jennifer, had a relatively amicable split. Their settlement agreement, which was incorporated into the final court order, explicitly stated that Jennifer waived any and all interest in Marcus's $401,000. Marcus walked out of that courtroom feeling secure. He assumed that because the judge signed the order, the deal was sealed. However, Marcus was busy rebuilding his life, and amidst the chaos of moving and setting up a new household, he forgot to log into his employer's retirement portal to change his beneficiary designation. 2 years later, in 2028, Marcus is involved in a tragic accident. When his parents go to claim his retirement savings to provide for Marcus's minor children, they are met with a shocking reality. The plan administrator informs them that the $400,000 is being paid out in a lump sum to Jennifer. Jennifer's attorney points to the 2009 Supreme Court case of Kennedy versus Plan Administrator for DuPont Savings and Investment Plan, which established a historical trend in federal law. The court ruled that even if an ex-spouse waives their right to the funds in a divorce settlement, the plan administrator must still pay the named beneficiary on the form. Because Marcus never filed a new designation, Jennifer remains the legal beneficiary in the eyes of federal law. This is not a hypothetical fear. It is a recurring potential outcome that has been upheld in appellate courts across the 8th and 10th circuits, which cover the Great Plains. The children are left with nothing, and the ex-spouse receives a windfall that the divorce court specifically intended for her not to have. Step by step, the 2026 Masterclass protocol for avoiding this loophole begins with the administrative audit. Do not rely on your memory of what you did 5 years ago. You must request a beneficiary confirmation statement from every single retirement account you own. In the digital age of 2026, many people assume that updating their profile on a mobile app is sufficient. However, historical trends show that technical glitches or unsubmitted, pending changes can leave the old beneficiary in place. You need a hard copy or a PDF confirmation that shows the date of the update and the names of the primary and contingent beneficiaries. The second step is understanding the power of the contingent. Many residents in the Great Plains name their spouse as the primary beneficiary and leave the contingent beneficiary blank. In 2026, this is a critical error. If you remove your ex-spouse but fail to name a contingent, and you pass away before naming a new primary, the funds may default to your estate. While this sounds like a safe bet, it often subjects the money to the probate process in states like Oklahoma or Kansas, where creditor claims can eat into the balance before it ever reaches your heirs. By naming a contingent beneficiary, perhaps a trust for your children or your siblings, you create a secondary firewall that ensures the money stays out of the hands of both your ex-spouse and the probate court. The third step involves the spousal waiver in a remarriage scenario. Let's say Marcus from our previous case study had remarried a woman named Sarah before he passed away. Under ERISA, a new spouse is automatically the 100% beneficiary of a 401k unless they sign a specific, notarized waiver. If Marcus had updated his beneficiary to his children but didn't get Sarah to sign a waiver, Sarah would still likely receive the money despite Marcus's intent. In the Great Plains, where blended families are a common social structure in 2026, the intersection of the first divorce is QDRO, the second marriage's automatic rights, and the federal plan document rule creates a three-way legal tug-of-war that can take years to resolve. Furthermore, we must address the interpleader action. When a plan administrator sees a conflict, for example, a divorce decree saying the ex-spouse gets nothing, but a beneficiary form saying they get everything, the administrator often doesn't want to be sued by either party. They will file an interpleader action, which means they hand the money over to a federal court and tell the family to fight it out. The cost of this litigation in 2026 can easily exceed $50,000 in legal fees, which is deducted directly from the 401k balance. This is the ultimate lose-lose scenario. Even if your family wins, they win a significantly smaller prize. A deep dive into 2026 case law reveals a narrow exception known as the post-distribution lawsuit. In some jurisdictions within the Great Plains, once the plan administrator has paid the money to the ex-spouse, the estate can then sue the ex-spouse in state court to recover the funds based on the breach of the divorce contract. However, this is a high-risk strategy. If the ex-spouse has already spent the money, moved it offshore, or lost it in a bad investment, a judgment against them is just a piece of paper you can't collect on. The only true protection is preventing the distribution to the wrong person in the first place. The 2026 Masterclass requires you to treat your beneficiary forms with more respect than the divorce decree itself. Step by step. First, Obtain the specific change of beneficiary forms from your HR department or the plan's online portal. Second, ensure you have the full legal names, social security numbers, and dates of birth for your new beneficiaries to prevent any identity confusion. Third, if you are naming a trust, ensure the trust language is compliant with the Secure Act 2.0 and its 2026 updates, which dictate how quickly beneficiaries must withdraw the funds. Fourth, and most importantly, get a stamped dated receipt of the change. But what if the 401k isn't the only account out there? In the Great Plains, where job hopping between agricultural giants, energy firms, and healthcare systems has increased in the mid-2020s, many individuals have ghost 401ks, forgotten accounts from employers they left a decade ago. If you divorce in 2026 and only split your current account, you are leaving a massive trail of vulnerability behind you. In the next part, we are going to dive into the great 401k treasure hunt, how to locate forgotten assets that your ex-spouse might still be legally attached to, and how to use the omission clause to claim your share of accounts that weren't even mentioned in the divorce. We will reveal the specialized 2026 tools for tracking down missing retirement funds across the U.S. and the legal steps to reopen a case when a hidden account is finally discovered. The Great 401k Treasure Hunt is not just a catchy title. In 2026, it is a necessary forensic procedure for anyone ending a marriage in the U.S. Great Plains. Because the region is a hub for the energy, agriculture, and logistics industries, the workforce is exceptionally mobile. We see a recurring historical trend where professionals move from a wind farm project in Kansas to a natural gas facility in North Dakota, and then to a corporate headquarters in Omaha. Each move often results in a new 401k plan, and over a 15 or 20-year marriage, it is remarkably easy to lose track of the ghost accounts left behind at previous employers. By the time 2026 rolled around, the Department of Labor estimated that billions of dollars remained in abandoned or orphaned retirement plans. If you are only splitting the account from your current job, you are likely leaving a significant portion of your marital net worth on the table. Imagine Thomas Miller, a specialized technician who spent 2 decades maintaining telecommunications infrastructure across Nebraska and Iowa. In 2026, Thomas and his spouse, Elena, decided to divorce in Kearney, Nebraska. They focused all their energy on their primary assets: the family home, a shared savings account at a local credit union, and Thomas's current 401k with a major regional provider. They reached a 50-50 agreement, the QDRO was processed, and they moved on. However, 6 months after the decree was finalized, Elena was cleaning out a storage unit and found a dusty envelope from 2012. It was a summary annual report for a 401k plan from an employer Thomas had worked for briefly in West Des Moines over a decade ago. Thomas hadn't hidden it intentionally. He had simply forgotten it existed during the high-stress period of the separation. This discovery moves us into the first step of the 2026 Masterclass discovery process: the Secure 2.0 retirement savings lost and found. Pursuant to the federal legislation passed years ago, 2026 marks the era where the Department of Labor's centralized, searchable database is fully operational. This is your first port of call. By entering your social security number and previous employer names, the tool can match you with lost plans where you still have a balance. For residents of the Great Plains, this tool is revolutionary because it cuts through the administrative fog of merged companies and defunct startups. If the company Thomas worked for in 2012 was bought by a larger conglomerate in 2018, the lost and found database tracks that succession, pointing Elena and Thomas to the current plan administrator. The second step is a deep dive into the Social Security earnings record. This is a move used by top-tier forensic accountants in 2026. By requesting a detailed earnings statement, you can see every employer that ever reported income for you or your spouse. You then cross-reference this list with your tax returns, specifically looking for Code D in Box 12 of the W-2. This code indicates elective deferrals to a 401k plan. If Thomas's 2012 W-2 shows a $3,000 contribution under Code D, but there is no record of that money being rolled over into his current 401k, that is a red flag that a ghost account exists. In the Great Plains, where many legacy employers have shifted from pensions to 401ks, these small starter accounts, from early in a career, can grow into $30,000, $40,000, or $50,000 assets through a decade of passive market growth. Now we must address the legal mechanism for handling these discoveries: the omission clause, often called the omnibus clause. A well-drafted 2026 divorce decree in states like Kansas or South Dakota should include a provision that specifically addresses after-discovered property. This clause typically states that if any asset owned by the parties at the time of the divorce was not disclosed or accounted for in the final decree, the court retains jurisdiction to divide that asset at a later date. If Elena's attorney included a robust omission clause, she doesn't necessarily have to sue Thomas for fraud. She simply files a motion to divide the newly discovered 401k according to the original 50-50 split. However, if your decree lacks this clause, you enter the high-stakes world of the motion to set aside or Rule 60B motions. In 2026, Great Plains courts generally require a high burden of proof to reopen a finalized case. You must typically prove mutual mistake, meaning both parties honestly forgot the account, or fraudulent concealment, meaning one spouse intentionally hid the account to keep it for themselves. Historical trends in Oklahoma and Nebraska case law show that courts are far more lenient with mutual mistakes. If Thomas can show he hasn't touched the account and truly forgot it, the court will likely just issue a new QDRO for that specific fund. But if Elena can prove Thomas was receiving statements at a private P.O. box and purposely left it off his financial affidavit, Thomas could face contempt of court charges, potentially resulting in him having to pay Elena's legal fees or even forfeiting a larger percentage of the discovered account as a penalty. Step by step, the 2026 treasure hunt should follow this protocol. First, use the DOL Retirement Savings Lost and Found database. Second, search the National Registry of Unclaimed Retirement Benefits, a private database used by many Great Plains employers to park funds of former employees they can no longer locate. Third, check the Abandoned Plan database on the AFAS2 website, which lists plans that have been terminated without a successor. Fourth, review every W-2 from the duration of the marriage for that Box 12 Code D marker. Fifth, if an account is found, contact the plan administrator to request a plan participant history report to see if any withdrawals or loans were taken out during the separation period. Imagine the potential outcome for Elena. The 2012 account she found was originally worth $8,000. But over 14 years of being invested in a standard S&P 500 index fund within the 401k, and considering the market upswings leading into 2026, that account is now worth over $35,000. Because they used an omission clause, she is entitled to $17,500 plus her share of the growth that occurred since the divorce. This is found money that can significantly impact her post-divorce financial stability in a city like Lincoln, where that sum could cover property taxes or health insurance premiums for years. But what if the account is a Roth 401k instead of a traditional 401k? This is where the Great Plains tax bomb comes into play. In 2026, we are seeing a massive increase in the number of Roth accounts being split in divorces. Many attorneys and even some judges still treat all 401ks as pre-tax assets, but a Roth 401k is funded with after-tax dollars. If you trade $10,000 of a traditional 401k for $10,000 of a Roth 401k, you are making a devastating financial mistake. In the next part, we are going to dive into the Roth versus traditional division, the hidden tax math that is causing equitable splits to be anything but equal. We will reveal the 2026 tax-affecting formula that ensures you aren't paying the IRS for your ex-spouse's retirement, and why the 5-year rule for Roth 401ks could block you from accessing your money, even if you have a valid QDRO. This is the part where we move from finding the money to keeping every cent of it. The complexity of the tax divide between Roth and traditional 401k accounts is the silent killer of many equitable settlements in the Great Plains. In 2026, we are seeing a massive shift in how these accounts are structured, with many employers in cities like Omaha and Fargo offering both options within the same plan. If you are going through a divorce and the spreadsheet simply shows $200,000 in a 401k, you are only seeing half the truth. $100,000 in a traditional 401k is fundamentally different from $100,000 in a Roth 401k. To treat them as equal is to ignore the looming hand of the IRS. Historically, traditional 401ks are funded with pre-tax dollars, meaning you get a tax break today, but you owe the government a percentage of every dollar you withdraw in the future. Conversely, Roth 401ks are funded with after-tax dollars, where you pay the tax upfront in exchange for tax-free growth and tax-free withdrawals later. Imagine Brian, a software engineer in Des Moines, who has a retirement portfolio split exactly down the middle. He has $100,000 in a traditional 401k and $100,000 in a Roth 401k. During the 2026 divorce mediation, Brian and his spouse, Sarah, decide on what they think is a fair trade. Brian keeps the entire $200,401,000, and in exchange Sarah keeps the family home, which has $200,000 in equity. On paper, this is a clean, equal split. However, Brian has just walked into a massive financial trap. Because his traditional 401k is pre-tax, that first $100,000 is subject to a potential outcome where he may lose 25 to 30% of it to federal and state income taxes upon withdrawal. His actual spendable wealth in that account is closer to $70,000. Meanwhile, Sarah's $200,000 in home equity is largely tax-free upon the sale of a primary residence. Brian is starting his new life $30,000 behind, even though the legal document says the split was equal. To solve this, 2026 Masterclass practitioners use the tax-affecting formula. This is a step-by-step mathematical adjustment that levels the playing field. To tax-affect a traditional 401k, you multiply the account balance by 1 minus the expected future tax rate. If Brian's effective tax rate is estimated at 25%, his traditional 401k is valued at $75,000 for the purpose of the marital split. His Roth 401k, being tax-free, remains at its full $100,000 value. The total value of the retirement assets is not $200,000, but $175,000. In this scenario, for the trade with the house to be truly equitable, Brian would need to receive an additional $25,000 in other assets to offset the future tax liability he is inheriting. Historical trends in Kansas and Nebraska courts show that while judges aren't always required to tax-affect assets, a well-prepared financial report can make it a compelling argument for a deviation from a standard 50-50 split. The next layer of the 2026 tax reality is the Roth 5-year rule. This rule is often the primary cause of denied access to funds, even when a QDRO is in place. For a distribution from a Roth 401k to be considered qualified, meaning completely tax and penalty-free, the account must have been open for at least 5 years, and the individual must be age 59 and a half. In a divorce, if Sarah receives a portion of Brian's Roth 401k via a QDRO and rolls it into her own Roth IRA, she inherits the 5-year clock from Brian's original 401k. However, if she is only 40 years old and needs that money to pay for a move or a new car in 2026, she cannot access the earnings tax-free until she reaches the age requirement. Imagine if Sarah assumes that because the money is in a Roth account, it is hers to use immediately without consequence. If she withdraws $50,000 of her settlement and $20,000 of that represents investment earnings, she could be hit with a surprise tax bill on those earnings because she hasn't met the 5-year and age requirements. Step by step, you must verify the start date of the 401k participation. If the account was started in 2023, the 5-year clock doesn't finish until 2028. This restricts your liquidity and must be factored into your 2026 post-divorce budget. We have seen case studies where individuals were forced to take high-interest personal loans because their settlement money was locked behind the 5-year Roth wall. Furthermore, the 2026 IRS coding for QDRO distributions adds another technical hurdle. When a plan administrator issues a 1099-R for a 401k split, they must use specific codes to tell the IRS this is a divorce-related transfer. For a Roth 401k, this code must correctly identify the basis, the money you already paid taxes on versus the earnings. If the QDRO is poorly drafted and doesn't instruct the plan to provide a detailed breakdown of the cost basis, the alternate payee might find themselves in an uphill battle with the IRS to prove that a portion of their withdrawal shouldn't be taxed. In the Great Plains, where state tax departments like those in Oklahoma are increasingly aggressive in 2026 regarding retirement audits, having this documentation is your only shield. Another critical step in the 2026 Masterclass is the separate accounting for the Roth and traditional portions within the QDRO itself. You cannot simply say half the account. You must specify whether you are taking half of the traditional subaccount, half of the Roth subaccount, or a specific combination of both. In a deep dive into historical trends, we find that many participants try to offload the traditional pre-tax portion to their ex-spouse while keeping the Roth after-tax portion for themselves. If you are the receiving spouse, you must insist on a pro rata split of both subaccounts or demand a tax-affected adjustment if you are only receiving the traditional side. Consider a scenario in Wichita, Kansas, where a couple is splitting a $300,401,000 that is 60% traditional and 40% Roth. If the participant keeps the $120,000 in Roth and gives the spouse $180,000 in traditional, it might look like the spouse got the better deal. But after taxes, that $180,000 could dwindle to $135,000. The participant, meanwhile, keeps every cent of their $120,000. The advantage the spouse thought they had is almost entirely eroded by the tax collector. Step by step, the 2026 protocol for tax-aware division is: first, obtain the most recent statement that breaks down the traditional versus Roth balances. Second, apply the tax-affecting formula based on your specific state's 2026 income tax brackets. Third, verify the 5-year clock start date for the Roth portion. Fourth, ensure the QDRO explicitly defines the allocation from each subaccount. Fifth, consult a tax professional to simulate the impact on your 2026 and 2027 tax returns. This level of detail is what separates a standard divorce from a masterclass execution. You have found the accounts, you have protected the valuation, and you have neutralized the tax traps. You are at the finish line. But there is one final critical phase that determines if you will actually thrive or just survive in the years following your 401k split. Even with the money in your account, if you don't know how to navigate the 2026 reinvestment landscape of the Great Plains, you could lose everything you just fought for to inflation or predatory fees. In the final part of our deep dive, we are going to reveal the clean break checklist. The 7 moves you must make within 72 hours of the funds hitting your account. We will explore the asset allocation reset and how to build a 2026 retirement strategy that accounts for your new single status. This is where we turn your settlement into a legacy. The moment those funds land in your newly established individual account, the clock starts on your new financial life. In the 2026 economic environment of the Great Plains, we see a recurring historical trend where the first 72 hours following a 401k transfer are the most critical for long-term wealth preservation. You have successfully navigated the legal minefields, the QDRO technicalities, and the tax traps we have discussed throughout this masterclass. Now you face the clean break checklist, a series of 7 mechanical moves designed to ensure your settlement doesn't just sit in limbo, but begins to function as the foundation of your individual legacy. The transition from a shared marital retirement strategy to a single self-reliant one requires a total recalibration of your financial DNA. Step 1 of the checklist is the hard landing verification. Imagine Linda, a mid-career professional in Sioux Falls, South Dakota. After 18 months of litigation, her $300,000 share of her ex-spouse 401k finally hits her brand new rollover IRA in May 2026. Linda's first instinct is to breathe a sigh of relief and close the app. This is a mistake. Step by step, you must immediately cross-reference the incoming balance against the final QDRO instructions. You are looking for more than just the large numbers. You are looking for the exact accounting of the investment earnings and losses that should have been applied between the valuation date and the distribution date. In 2026, we have seen case studies where plan administrators make clerical errors in the pro rata allocation of dividends. If Linda's account is even $500 short, she must notify the administrator within that 72-hour window. Once the funds are accepted and the administrative file is closed, the historical trend shows it becomes exponentially harder to correct an underdistribution. Step 2 is neutralizing the cash drag trap. When funds are moved via a QDRO from a 401k to an IRA, they are almost always liquidated into cash or a money market fund during the transit. In the volatile 2026 Great Plains market, where energy and agricultural sectors can see rapid intraday shifts, leaving your entire settlement in a cash settlement fund is a high-risk move. Imagine Kevin in Omaha, who received $400,000 into his IRA. He assumed the money would stay invested in the same S&P 500 index funds he had in the 401k. However, because it landed as cash, Kevin missed out on a 3% market rally that occurred while he was busy settling into his new apartment. By the time he checked his account 3 weeks later, he had effectively lost $12,000 in purchasing power simply because he wasn't invested. Your step-by-step priority is to execute your new buy-in strategy immediately upon the funds clearing. This leads directly into step 3, the individual asset allocation reset. When you were married, your retirement strategy was likely part of a 2-person puzzle. Perhaps your spouse held the aggressive growth stocks while you held the conservative bonds, creating a balanced household portfolio. Now that you are single in 2026, that balance is gone. You are likely holding a lopsided asset mix that no longer fits your personal risk tolerance or your individual time horizon. A deep dive into the 2026 Great Plains economy suggests a need for a standalone diversification strategy that accounts for the fact that you no longer have a second income as a safety net. You must reevaluate your capacity for loss. For many in the heartland, this means shifting toward a more defensive posture or, conversely, realizing they need to be more aggressive to make up for the loss of their spouse's future contributions. Historical trends indicate that individuals who fail to reset their allocation within the first month of a divorce settlement often carry inappropriate risk levels for years, leading to potential outcomes of significant underperformance. Step 4 is the 2026 fee compression audit. Many 401k plans for large employers in Kansas and Oklahoma are notorious for high administrative fees and expensive captive mutual funds that can charge upwards of 1% in expense ratios. Now that your money is in a self-directed IRA, you have the power of the 2026 open market. You can shift from a fund charging 1% to a low-cost exchange-traded fund charging 0.05%. On a $500,000 settlement, that simple move saves you $4,750 every single year. Over a 20-year retirement horizon, that single audit adds over $100,000 to your final balance through the power of compounding. This is how you turn a divorce settlement into a legacy. You stop the silent leakage of your wealth into the pockets of fund managers. Step 5 is the beneficiary and contingent chain finalization. We have talked extensively about removing your ex-spouse, but the 2026 masterclass requires you to go further. You must now build a multi-layered succession plan. If you have children, you must decide if they inherit the IRA directly, or if the funds should flow into a specialized bridge trust to protect them from their own creditors or future divorces. In the Great Plains, where family land and heritage are paramount, we are seeing a 2026 trend toward using IRA assets to fund dynasty trusts that provide for multiple generations. You must name not only a primary beneficiary but at least 2 levels of contingents. This ensures that even in a worst-case scenario, your hard-won 401k share stays within your chosen circle of influence and stays out of the hands of the state probate courts. Step 6 involves the tax document safety box. The 2026 tax year following your divorce will be one of the most complex you ever face. You will receive 1099 or forms from the 401k administrator, and if you utilize the 72T liquidity exception we covered in Part 4, your tax return must be coded with surgical precision to avoid the 10% penalty. You must create a physical and digital folder containing the signed QDRO, the plan administrator's confirmation of the 72T exception, and the cost basis breakdown of any Roth portions. Historical trends show that the IRS often flags large retirement distributions for automated audits. Having this safety box ready allows you to resolve an audit in days rather than months. Finally, Step 7 is the wealth mindset shift. For years, your 401k was a shared number on a joint spreadsheet. In 2026, you must begin to view it as your individual engine of freedom. This means setting up new, automated contributions from your own salary to your new IRA or your new employer's 401k. The goal is to replace the lost portion of your retirement as quickly as the 2026 cost of living allows. By following this 7-step checklist, you move from a state of financial defense to a state of strategic offense. You are no longer just surviving a 401k split. You are mastering the art of individual wealth. As we conclude this deep dive masterclass, you now possess the technical roadmap to navigate one of the most complex financial events in the American heartland. From the first filing in a Great Plains courthouse to the final reinvestment in your personal IRA, every move has been calculated to protect your purchasing power and your future. But while the 401k is often the largest liquid asset, it is only one piece of the post-divorce puzzle. For many residents of the Great Plains, there is another looming giant that is often handled even more poorly than the retirement account: the family home and the hidden dangers of the 2026 mortgage market. In our next specialized series, we will dive into the high-stakes real estate divorce, revealing why the standard buyout is often a trap in a high-interest rate environment and how to protect your credit score when your name is still on an ex-spouse's deed. The journey to total financial independence has just begun.